Our next talk is conflict resolution, using descriptive psychology to negotiate relationship change by Paula Holt. Paula grew up in Colorado, specifically coming to SDP annual conferences since she was a young child. One of her earliest memories is riding horses, or she has an early memory, of riding horses up at Aspen Lodge with Julia and watching Walter play his guitar. Since then, she's grown to incorporate descriptive psychology into her legal practice and teaching career. She went to Arizona State University for her bachelor's of finance and marketing, and then received a master's in business administration from the University of Denver, where she also completed her Juris Doctorate in 2009. She is currently completing a master's in conflict resolution. That would be the third master's, huh? Which is where she believes DP will have the most influence. This led to a decision of applying DP to negotiations as she plans to present at the conference this year, obviously. Another important fact that was called to my attention this morning is that Paula has been teaching a class in alternative dispute resolution, and it has been ranked the top undergraduate class at the Daniels College of Business.
My mother added that last fact. Jean, Charlie is going to miss it, but I hope you'll appreciate that I absolutely can accept and appreciate lawyer jokes, so I've got one for you. So, as most of you know, I'm a divorce attorney, and that comes with a very positive stigma, I'm sure. So there's the favorite joke that I always hear is, if you get divorced in Kentucky, are you still brother and sister? I know, awful, right? So, I wanted to start out today with a description of my alternative dispute resolution class. And so, I'm very fortunate that I had a photographer friend who came in and actually took pictures of my students doing negotiations. So the pictures that you'll see throughout my slideshow today are actually my students engaging in the actual types of negotiations that I'm going to be discussing today. So I kind of feel really special about that, and you can ignore the parts that have me in them. So the ADR class, Alternative Dispute Resolution, is my baby at the University of Denver. I created it from scratch to teach business students how to negotiate conflict and high litigious situations in the business arena. But certainly it also extends, or the concepts that they learn and the skills that they learn extend into other relationships. That could be familial, romantic, business, workplace, all sorts of different negotiation situations. I put them through a series of different negotiation practices. So they are given characters, and they're given scenarios, and then conflict that they have to negotiate among themselves. And that's what the pictures are. They're negotiating these high conflict kind of business cases. One of my favorite ones is starting out the class the very first day, where they have to negotiate a hostage situation with a hostage taker. And they're given roles to actually take on either the role of the hostage taker, who's desperate and has people held at gunpoint, or the role of the police trying to negotiate the safe release of the hostages. Then they move into more business types of situations that are dealing with product liability. So a business to a consumer, when a consumer has been injured. The specific example is a play school crib that injured many infants when it was a defective product. They go into various other business situations in which they're negotiating their own wage salary with their boss. As well as any kind of workplace conflicts like a hostile work environment or sexual harassment. And then they even get into some divorce or family law disputes, because it wouldn't be fun for me if I didn't get to use my own client cases to see how my students could deal with them. So I make them negotiate against me, wherein I portray one of my crazy clients or one of my crazy opponents, and I see how my students can manage the negotiation situation with me. So in teaching alternative dispute resolution, it's important to understand the context of where this fits in the legal world. Alternative dispute resolution is an alternative to court. So by the time a lawyer steps in, you're at a litigious point, right? You filed a lawsuit, you're headed down the road towards going for a judge and jury to decide or resolve your conflict. And the overwhelming policy process throughout the US is to move litigation towards ADR, towards the various forms of ADR. In fact, we've passed several federal and state statutes that require lawsuits, court cases to go through ADR before they're allowed to see a judge and a jury. And in many instances, in this day and age, with the numerous amount of contracts that we sign on a daily basis, you're actually waiving your right within these contracts to a court case and agreeing, maybe unknowingly, to subject yourself to one of these forms of ADR and completely forego your right to a judge and jury altogether. So we see a huge national policy trending towards making people go through ADR steps without ever seeing a courtroom, a jury, or before they're allowed to get there. So in teaching ADR to my students, they're usually juniors and seniors at the undergraduate level. They're not lawyers, they're not law students, they're business students, but some of them have a desire to be pre-law or want to emphasize their studies in some kind of legal and ethical studies. So the teaching lessons or the learning objectives that I'm intending to get for my students are the acquiring of basic analytical skills necessary to engage in a negotiation, the ability to integrate basic ethical concepts in today's dispute resolution environment, and the ability to appreciate the distinction between an ethical and a legal judgment and to deduce useful methods of settlement discussions. That's exactly where I feel DP fits in, and I've tried very hard over the last 5 years of teaching this class to incorporate some DP concepts into teaching them how to negotiate conflict. So my learning objectives today for this presentation specific to this group are to include the identification and of the distinctions and principles of descriptive psychology that can apply across the broad spectrum of relationships, to discuss ways in which descriptive psychology can build essential negotiating skills and a variety of ways to become competent at facilitating relationship change in conflicts, to demonstrate ways that people need to be treated as persons, as someone who makes sense in order for productive communication to occur in conflict situations and avoid the escalation of arguments, and to indicate how successful conflict resolution builds in ways for a person's perspective to be respected and considered valid so you're on their side. So I'm sure you can hear the descriptive policies coming out. So it's important to distinguish the various types of alternative dispute resolution. You've got negotiation, mediation, arbitration, and then of course the last result if they don't work is court. So the idea of ADR is actually to take a series of steps and processes to avoid going to court. Alternative dispute resolution is the formal process to resolve conflict without a formal court proceeding. So the goal is to avoid actually having to go to that judge and jury. So I'm going to give you a brief description of what each of these are from the legal perspective, so you can kind of have an idea of then where I try to implement the DP. So negotiation, from a legal perspective, is stereotypically against what you think a lawyer is for. Right? A lawyer is intended to argue and litigate and make judgments or take positions. And I think that actually the biggest part of my job for my clients is really not doing that, but finding a way to use my judgment to bring up seemingly legitimate offers and positions that will resolve the conflict without court intervention. And this is where I found an amazing quote from Pete in the variety of gems that my mom provided to me for descriptive material. And Pete said that the social practice of negotiation has been discussed as the paradigm for the resolution of disagreement among critics of a given description. So the idea is that I'll later discuss how Pete distinguishes between a negotiator and a bargainer. And bargaining is really where we think of lawyers coming in to try and make compromises or trade-offs. But the goal in negotiation is actually to change the relationship of the people in conflict. So mediation, therefore, if you're not familiar with the process, is using a third-party facilitator to negotiate kind of the parties from a neutral standpoint. It's the process in which an individual, unrelated to either party and outside of the conflict, facilitates communication and the negotiation on behalf of the parties. I always find it surprising that people don't realize how mediation actually plays out. In the litigation context, when you've actually filed a court case and you're mediating because a court has required you to, mediation actually plays out like this. The two parties are in separate rooms with their respective attorneys, and the mediator, that facilitator, actually moves between the two rooms. I think we commonly think of a mediator sitting at a table with the two parties right in front of each other, but that rarely works out well. That doesn't actually help, because the idea is to separate the people from the problem, right? We need to separate their emotions and we need to separate them from the conflict, and so we do that quite literally by putting them in separate rooms. So the mediator facilitates by shuttling back and forth between the rooms. And there are three styles of mediation that a mediator can employ while still following their legal and ethical requirements to remain neutral and ensure that the parties reach this agreement of their own voluntary will. So the mediator can't really push them or force them, but their goal is to facilitate a resolution. So that leads me to the first style of mediation, which is facilitative. The facilitative mediator helps the parties define and understand the problem so that they can resolve it as they wish. The focus is on communication skills. The mediator helps the participants understand the legal positions to help them become realistic about their litigation situation and the facilitative mediator resists crafting options, but rather simply asks questions to attempt to reframe the perspective for the participants in the conflict. The next style of mediation is transformative. The transformative mediator focuses on the people and their interactions rather than the dispute. So the transformative mediator seeks to enable moral growth, because a dispute simultaneously causes people to act badly and feel as though they have no control over their circumstances and reactions. The goal here in transformative mediation is to allow the parties to continue their relationship after the conflict. This is enabling each party's capacity to analyze the situation and make effective decisions in order to strengthen their relationship. So the transformative mediator is less about resolving the conflict and actually fixing the relationship between the parties. The evaluative mediator, which is where we see a lot of litigation, is the person who works with the parties to discuss what will happen if they don't reach a settlement. So the evaluative mediator actually illuminates each side's obstructive perception of litigation and what court will actually look like if they don't settle. So the evaluative mediator tends to have expertise in that particular legal field or that particular issue or area of conflict to help actually develop and propose solutions. And I think that it's not well understood that those three types of mediation are very distinct in how they come into play in conflict from the legal world. Arbitration is the process of a small kind of court procedure. So arbitration is in effect like a mini court trial. It is using a neutral third party, but this neutral third party doesn't facilitate resolution. They actually decide the case. So they act as a judge. They have to be neutral and unbiased, but they're not facilitating any kind of resolution. They're hearing evidence, they're hearing testimony, they're hearing the arguments of each side, and then they're making a binding decision. So it's essentially having a judge decide your case. But the benefits of arbitration is that it's private, it's usually quicker, and it's usually more cost-effective. getting to court actually can take a series of years and hundreds of thousands of dollars before you ever see that judge and jury. So the idea of alternative dispute resolution is to minimize the economical issues that we have financially with the judicial process and how litigious we are as a society. It's very unique to our culture in America to be as litigious as we are. And our judicial process is so backed up that it becomes more expansive and takes twice as long simply because how many lawsuits we have filed in the US. And of course, if all else fails, we go to court. My goal in using descriptive psychology and teaching my students negotiation skills is to help them see the benefit of avoiding court, which I think sounds counterintuitive to being a lawyer, right? Don't get me wrong, I love being in court. I think it's so much fun, and I like to argue, but that doesn't necessarily benefit my client. And I think sometimes it gets lost that as an attorney, I represent and embody my client. I represent his relationship to the other party, his or her, and I'm representing them through the entire process, beginning to end, as this relationship changes. If whether it's a romantic relationship that's ending in divorce, or a work relationship that's terminating and firing and suing your company, the attorney acts as the advisor and should, in effect, help negotiate a change in the relationship that doesn't always have to end in a nasty knockdown, drag-out fight in court. So that's kind of where I see and have actually implemented some DP application. And I wanted to share that I got all the material from my mom and T that were giving me your guys' papers or dissertations or the advances. And as I got into the material, I was getting so excited. It was like you guys were speaking right to what I want to do, that I got overwhelmed and I couldn't really use all of it. So certainly I see that there's a future of a further presentation that could expand on this. And I'm going to try and keep my presentation to what I could legitimately grasp at this point in time. But I was so excited about all the different material that I had at my hands, thanks to you guys, to learn and apply DP for my students. So one of the things that is critical in negotiation, and it's a pretty well-known concept, is the idea of distinguishing interests versus positions in negotiation. So a position is something that the other side says they want. So we've always heard in litigation it's, I want $1 million, right? Or I want some sum of money. And that's the position they're taking. It's their line in the sand that says, this is what I want. But the important piece of that is there's some underlying motive. There's a reason that they want what they say they're wanting. And a good negotiator uncovers that motivation, which we call the interest. Right? So what is the interest behind their position? Why do they want what they want? And I've taught my students to ask questions and facilitate uncovering that interest by using our basic human needs. And I started with Maslow's basic human needs because that was what I had readily available. And my mom provided me with Lane's article on coal mining that he did, which actually expanded the basic human needs using Layton, right? And Lane was so nice to give me an additional material on Layton's basic human needs. I won't go through all of them. I think some of them are self-explanatory, and I'm sure this group has a wealth of knowledge and understanding on the basic human needs, but I'm going to highlight a few that are most critical in conflict resolution from the legal setting. So certainly physical health and safety and security are almost key at the beginning of every litigation. We say we want $1 million because really the underlying interest is if we've lost our job or we're separating from our spouse, we need money to make sure that our health, our physical well-being, our medical needs, our shelter needs, our food needs are taken care of. And so in uncovering that interest, as obvious as it sometimes may be, the idea behind $1 million doesn't really have meaning. But when you uncover that the interest is to take care of their physical needs or their safety and security, then you can calculate what amount of money they actually need to satisfy that issue or that interest. The one that I'm going to skip to personal and social legitimacy in a second, but I also want to hit on identity. Not specifically because I have much to say on it, but because I think it's such a perfect example of how the law and DP can complement each other. If many of you probably know, Obergefell v. Hodges was the Supreme Court case that was issued in June of 2015, this year, on same-sex marriage. It was a pretty highly popularized or media case about the Supreme Court's decision to essentially legalize or enforce or support same-sex marriage. Justice Kennedy in that case, though, opens his opinion with this quote: "The Constitution promises liberty to all within its reach that includes certain specific rights that allow persons within a lawful realm to define and express their identity." So he's providing, right there in this case, I think a very beautiful idea of DP, that this Constitution, the foundation of our nation, allows us certain rights as persons to express our identity. And I know Justice Kennedy doesn't know it, but I think that was a pretty beautiful DP quote. So maybe I'll write them one day. And so I think that that is so important that we see those things not as not deep psychology and law as combative, but actually as complementary. So then, of course, getting to the personal and social legitimacy, that's really where I focus a lot of my attention in a lawsuit. Because personal and social legitimacy, right, it's the idea of living in a way considered right and fitting by oneself. And it's adhering to the social customs, behavior, and laws of the society in which one lives. And when we are in a litigation, when we're in a lawsuit, we're essentially saying that this need, this personal and social legitimacy, is not being met, right? We're lacking it because we believe that we have been wronged in some way. Many of my clients, they want their day in court. They want their justice because they believe the other side has wronged them or violated the laws of the society in which they live. So it's really important then not only to try and address the opponent's in a negotiation need for addressing their physical health, their safety, their identity, a lot of times their autonomy or belonging with their company or in society, but when we get to the point of actually filing a lawsuit, we see that then there's this deeper basic human need that's not being met. And we see people engaging in behaviors specific to the idea that they're trying to satisfy that need. And so they're filing a lawsuit because they're trying to satisfy or legitimize their personal and social status with what in this relationship. So with that, my students then have to ask questions and they have to engage in practices. And for me, my clients, on their behalf, I have to engage in questioning and research and interrogation almost to discover what the other side's needs are, what their basic human needs, which ones are lacking, aren't being met, and how can I make an offer to satisfy their needs. And I don't think attorneys get enough credit because we are seen so litigious that, at least from my perspective, not all attorneys, of course, some are bad, but that I am trying to address the other side's needs so that they can in turn then address my client's needs, right? And a lot of times I'm even having to negotiate with my own client to figure out what their needs are because they just want to stick the bastard to the wall, right? They just want to screw him and they come to me and that's what they want. They think they're hiring a bulldog. And I have to be clear that that's not my role. And I'm actually guiding them through this process to kind of transition from a high conflict relationship to one where they either can graduate and just separate from each other or they can coexist. In the family law arena, they usually have to co-parent after this divorce case is over. So we need to get them to a place where they can actually do that. And I think there are a substantial amount of attorneys in court cases that hurt that process, that make it almost impossible for them to be able to work again after their day in court, right? So then in negotiating, you kind of exchange offers. You submit a proposal. Here's what I would suggest to resolve this case. Here's what it will take to not go to court from our perspective. And so it's a series of back and forth, which is why I thought it was really important to highlight Pete's distinction between bargaining and negotiating, right? I think far too often attorneys engage in bargaining and it does a disservice to their client. And so Pete indicates that the bargainer is engaging in a series of trade-offs to find a compromise that the parties can just live with. Whereas negotiation is intended to actually change the world in which they live so that they can have relationship change, so they can understand the other person's perspective and be compatible with their relationship. And with that, we have to kind of distinguish what is good negotiation in the legal world, because it costs my clients a lot of money to have me go back and forth, right? They pay a lot of money for me to negotiate on their behalf, and so at some point I have to decide, is this productive negotiation or is it not? And so then I'm dealing with the idea of the rational versus irrational negotiator. So many times we leap in law to everyone's just irrational. We leap to they don't make any sense and they're just irrational and let's just go to court. But I think that that's incorrect. I think that there's actually 3 different levels of that. Certainly at the top is the truly irrational person, where all rules and normal constructs and discourse will not work, so we go to court. But I think that there's some levels before you get there. And coping with difficult negotiation partners, we tend to jump to that assumption without realizing or investigating whether or not the other side is simply misinformed, whether they have unknown constraints, or maybe there are those hidden interests that we talked about before. So someone can be rational but misunderstood, right? You might be negotiating with someone who can be perfectly rational, but you're not understanding how the world looks to them. And that's where a mediator is helpful in this process, because they can come in as a neutral third party and in each side's room individually work to actually treat this party in the conflict as a person, to show them what sense they make, and to be on their side, right? Which is the descriptive policies that you all know and love, right? And I think that it's hard as the lawyer to necessarily do that for the opponent, but that's why getting a mediator involved in this process can be so helpful. Because I'm going to treat my own client as a person, even if, as my mom says, even if what sense they make isn't good sense, I'm still trying to show them what sense they make so that they can feel that personal and social legitimacy from me. And then the goal is to try and get them to feel the personal and social legitimacy from the other side, and vice versa. And I can be on their side, absolutely. They hire me to be on their side as their attorney. But the mediator helps find some middle ground in being kind of on both party sides, treating both people as people and showing them what sense they make. And that's really where I think the mediator helps in this negotiation process, but can implement these policies. So I'm teaching my students these policies as they go in, and as you see here, Chase over here, this gentleman in the suit to your right, he's actually the mediator in this negotiation. And he's trying to negotiate between this defendant and the plaintiff who's in the other room, right? And so I know you can't tell this and you're just going to have to trust me, and I know I'm a lawyer, but he's actually talking to them about what sense they make and trying to help them see what sense the other side makes, and trying to help them understand the other side's description of the conflict, right? And so we then will get to the rational person, but the irrational position. So that's where we see that they might have an unknown constraint. Sometimes you're negotiating with someone who seems to understand you and you seem to be making progress and you make a deal and then they say, oh, but my boss needs to sign off on this. Right? And they take it to the boss and the boss says, nope. Or you could be negotiating a contract and you think you're doing a good deal with 2 business salesmen and then they say, the legal department needs to approve it, right? And the legal department never approves it. So usually we think the other side is being irrational when they come back and say our deal is blown up. But really what happened was you weren't dealing with the right person. You weren't moving, you need to move to the top, the person who actually had the authority to negotiate with you. And so those are really important aspects of negotiation is instead of leaping to them being irrational, you've got to get to a place where you can understand and they can see what sense they make. And then I was able to really have some fun with this idea of escalation of arguments because, of course, what attorney wouldn't escalate an argument? That's what we do, right? We love to argue and train specifically for that purpose. And far too often, they intentionally escalate the argument just for the fun of it. Just because that's what they think is what an attorney is for. I can share a myriad of stories where the opposing counsel will call and just fight for the fun of it. And he'll know that the legal position I'm taking is right, but he'll just do it, just to get on the phone and bill his client for a half an hour of talking to me, right? And my favorite one is always, right? It's always the older attorney, because the legal field is somewhat still of an old men's club. And I'm always kind of dealing with the older male attorney who says to me, "Sweetheart, just accept the deal." And I always...
Yes, you do, right?
Oh, of course. I usually respond in kind with, "Sweetheart, I think our conversation's over." Right? And those are the ones where it's actually even more fun for me to go to court and kick their butt, right? But that doesn't necessarily do my client a service or help the conflict or in any way change the relationship or the dynamic between the parties who are going to have to live with each other after we step out of the picture and, stop messing with each other. So attorneys absolutely escalate the arguments, if not just because it's fun and we can. The goal then is really where I think that George Kelling, if you know him, wrote this article, and I'm going to share a series of ideas that he provided to me, which I think are beautiful, descriptions of how we can avoid the escalation of arguments. And he says that in negotiating, given some set of facts, a number of alternative descriptions might be offered, any of which are at least eligible for adequacy, and many of which might satisfy our own requirements as both observers and critics of the other side's description. Each negotiator assigns different weights to the facts of a conflict, which may alter the significance of the state of affairs being considered. Negotiators typically, however, choose to ignore the facts altogether, ignore the description, and instead challenge the describer. Their status and their personal characteristics, challenging those, are what lead to the escalation of arguments. So I'm sure, as you all know, we have situation descriptions, personality descriptions, and then he talks about damage descriptions. Right? And that a good negotiator focuses on the situation description rather than the personality description. And that's far too often where I see lawyers breaking down, is that I get the sweetheart comment, or I get the personal attacks of "you just don't understand." You guys might appreciate this one. Within my first year of practice, I had an attorney call me, and she had filed on behalf of her client a request for a dissolution of the marriage by invalidity. It's essentially an annulment. But these parties had been married for 3 years and had a 1-year-old child. Her desire to get the annulment, or her client's desire to get the annulment, was because of his Catholicism, his religious faith, and wanting to invalidate the marriage so that he wasn't violating the tenets of his church. But in the state of Colorado, there was absolutely no legal grounds for an invalidity of this marriage. And so we're talking on the phone, and we're going back and forth. I asked her, "Well, we need to convert this to a dissolution, divorce, because there's no legal basis for your claim." And she says to me, "I think your client needs to get an attorney who understands the Catholic religion. You are clearly not Catholic." I said, you're right, I'm not. And again, our conversation's over, right? And that one was really fun to go to court and kick her butt. But the idea was that in that situation, I'm frequently faced with people attacking me, my personal characteristics, my behavior, at the expense of actually resolving this case, and at the expense, quite literally, of the monetary value that this is imposing on the client. And so what I've taught my students, and I'm still learning to do myself, is to reframe to focus on the situation description, right? You can call my client controlling, you can call my client greedy for the child support and alimony she wants. But the requirements for filling your offer, for filling the parenting time that you've proposed, don't take into account travel, don't take into account a variety of different facts that describe the situation. And so it's critical for the negotiator to be able to recognize the personality description versus the situation description, and be able to then reframe it to refocus on the actual problem at hand. Thanks, Ray. So negotiation can serve as a method by which individuals may establish the significance of a state of affairs when descriptions of it have been called into question. So that's really where we see the law coming into play, is that each party has a different description of the facts and the issue, and they're calling into question the other side's description. So we're trying to kind of navigate through both of those ideas. And every negotiation will then guarantee some resolution, whether it's by agreement or by the court-imposed resolution, but it will be different for each participant. It will either provide each person an understanding of his fellow negotiator's perspective as compatible with their relationship, or the relationship has to change so that each person's understanding of the other person's resolution will then be compatible. And so that's where we see George Kelling adding on to this idea that an argument involves alternative descriptions of the same behavior, with each participant trying to make his description the only extant one. An argument can therefore weaken the relationship depending on the descriptions used, and that's where we see the situation versus the personality descriptions, and then that's where the damage descriptions come into play, where my description of your personality has done me some damage, has done me harm, actually caused me harm, either monetarily or personally. So arguments escalate depending on the degree to which we focus on the situation descriptions versus the personality descriptions. And that's where I think a lot of negotiations break down. So I actually have for you a case formulation where I'd actually like your help in negotiating relationship change for one of my clients. So I'm gonna just use mom and dad and avoid any names, certainly. Not my mom and dad, no. Did she think I was talking about her? I'm sorry. I meant the parties in this case are mom and dad to 2 children, in fact. Nothing to do with my mother, but a custody case that I have. So this is what we call an APR case. In Colorado, we call it allocation of parental responsibilities. It's popularly known as custody, but Colorado tries to be PC, so we call it parental responsibility. But it's essentially a battle over the children. The reason that it's an APR case is because the parties were never married. So we have the parties in this case, which are the parents of 2 children, a boy who is 3 years old and a young girl who's only 19 months. They were never married, but resided together in Colorado for several years after college, where they both met and received engineering and science degrees. They maintained their residence in Colorado until Dad took a contract job in Montana in March of 2012. It is important to note that Dad's family, his immediate family, his own parents, his siblings, and cousins live in Montana. Funnily enough, Great Falls, Montana, which is where my father happens to be from. So I swear, it's not my mom and dad. At the time that he moved in 2012, the parties were still engaged in a romantic relationship, but Mom remained here in Colorado. And they didn't have kids at that point, but Mom was pregnant. They had their first child that August of 2012, their son. Father was not present for the birth of the child and didn't visit until that December of 2012. But he would come to visit each winter for seasonal months off from work. And so he'd be here in Colorado visiting from approximately December to March of 2012 and 2013, when his employment in Montana actually terminated. And at which point he claimed he couldn't afford to visit anymore. However, somewhere along that time frame, they got pregnant with a second child, who was then born in 2014, in March of 2014. Dad, again, was not present for the birth of that child, and in fact did not meet the daughter until she was 9 months old. At which point, his visits became more infrequent, and he made little to no attempts to find employment in Colorado or be near the family, and the relationship at the romantic level terminated. They not only were physically separate, but emotionally they no longer were engaged in a relationship. However, they were somewhat attempting to co-parent these children from a distance. So, approximately in February of this year, 2015, Mom, feeling frustrated by the lack of Dad's involvement, sought to the state of Colorado to get child support. So you don't actually have to file a legal lawsuit in Colorado to get child support. You can just request it from the state and they'll award it and they'll calculate it. So Mom was able to receive child support from the state, and they garnished Dad's wages. He was at that point reemployed. And upon the first garnishment of his wage, I bet you can imagine what followed. So when he receives his first check deducted by $1,500 for child support, he hires an attorney here in Colorado and responds in kind with a custody or an APR action to obtain 50-50 custody of these two children. Now, a 50-50 schedule with Dad in Montana and Mom here in Colorado is somewhat of a logistical nightmare. So that aside, especially considering that they're 3 and 19 months, that part aside, what happened, or what I saw transform, was they went from a romantic relationship to a relationship where they at least coexisted somewhat and co-parented from a distance, to now this highly litigious relationship. And the personal characteristic attacks that they make on each other on a daily or weekly basis, it's pretty absurd and really disappointing from my perspective. And so we see here that Mom wishes for both children to have a loving relationship and bond with the father, but she believes Dad to be unmotivated, and specifically has described him as incapable of parenting the children. Mom's concerns are exasperated by her frustration that she thinks this is purely monetarily motivated from the child support. At which point, Dad, of course, describes and sees Mom as controlling and greedy. So she's controlling the children. She won't allow him time with the children. She won't trust him with the children, and is only after his money. So you see them transforming from somewhat of a co-parenting relationship to a focus on describing personal characteristics and attacking those personal characteristics. Their arguments have escalated to focus on each other's behavior, where Mom thinks him to be incompetent and he thinks her to simply be selfish, and several other curse words that he's used, but I won't share. As we're trying to transition into a relationship, or into the formal kind of finality of their case, we're set for hearing in December. And we have actually 2 specifically court-appointed experts who are investigating each side's parenting abilities, because they've been called into question. Right? They're questioning each other's actual ability. And really, they're questioning that personal and social legitimacy in this world as a parent, and as a provider in the realms of what legally is required for child support. So what I'm asking from you guys is not necessarily to help me craft a parenting schedule, because got that covered, or the court will do it. But what I'm hoping that you guys can do is really help me use DP concepts, either those that I've described today or others that you think I may have missed, to formulate ways in which I can further negotiate a change in the status each of these persons holds in the other's world. And so I'm really looking for help in negotiating their relationship to change the way in which they see each other.
It's funny, the case that you're describing is almost exactly parallel to a case that was brought up in my supervision seminar by a student who's working for the court systems in Boston and serving as guardian ad litem for the children. I guess my question is to sort of further the question that might have something to do with the point at hand. Who finally has to say about, once the reports are in, about what's in the best interest of the children? With that in mind, what this guardian was trying to do, because she had really strong feelings about one parent and really positive feelings about the other, which she could not justify legally, and nor could she justify it given the facts, just the way she felt in her gut. So the question of how she would actually create a level playing field of explanation about the interests of the child and these two parents was a very, very difficult thing to adjudicate. The tension that she was experiencing, which was really tearing her apart in the seminar, is if I make this statement, the court in fact is going to accept it and make this judgment, but I'm in a position where there's no way in hell I can actually make this statement in good faith. And so what I'm wondering is, how does the court here work through who adjudicates and how do they work with the notion of what's in the best interest of the child?
That's such an excellent question, Wynn, and it makes me really excited because I think the one thing that I get to add to value at this conference is the legal perspective. And in Colorado, which may be different than Massachusetts, our laws, there are actually 24 factors that the court has to take into consideration for the best interest of the child. And I've actually been very successful at getting a court to ignore, on multiple occasions, in multiple cases, to ignore the expert and what they say. Because sometimes the expert is wrong. Because
the expert has such a tiny window of time for evaluation.
And a limited amount of resources. In Colorado, they're capped at $2,000 for what they can charge for their investigation. And they're doing 50 hours of work.
And plus, when the evaluator is dealing with these two parents, the parents are often in a hostile situation with the evaluator from the beginning, so they don't really get to see the more, I mean, it's just such a messy situation.
They don't trust the evaluator because they see the evaluator as a judge, essentially, and the evaluator sits in their home and observes them as they parent. So the evaluator is judging them as they parent, and they're really good. My mom is one in the state of Colorado, is what we call a CFI, a Child and Family Investigator, and I need to ask her someday why do they do this, but they're really good at making the person feel as if they're on their side and as if they make sense. So my clients always come back being like, that was a great interview, it was wonderful, she loved me, and then the report comes out so against my client, right? And so they don't trust them for that reason, and the court is actually challenged with the obligation to hear the evaluator's report, and as an attorney, I'll challenge their investigative process. I'll challenge the psychology, and I've always got someone looking at my reports before I go to court. So I'm cheating almost in a sense, because I get to understand more of the ideas in which it's challengeable. Then the court hears the evidence of the parties, so the court gets to observe the demeanor of each parent and the way in which they testify, and the court determines how credible each parent is.
In this state, does the child have a separate agent apart from the
No. In Colorado, we don't have a separate agent. A guardian ad litem is only appointed if there's some kind of abuse or neglect. And so they don't have an agent in Colorado. That is the rule of the CFI. So they are trying to the judge has to hear in such a limited amount of time.
So it's child as chattel.
Yes. Well, and people say, I want my day in court, but they don't realize that that's just one day. And you only get half of that day because the other side gets the other half. So you want me to take these 2 years of litigation, all these experts, all these witness testimony, all this evidence, and you want me to compile it into 4 hours of a case to present to the court, and you think you're going to win? I mean, a lot of times I'm trying to negotiate with my own client what that risk looks like. Right? Because that's a judge, and it depends on how he feels that day, what he had for breakfast, if his own wife has not given it up, right? So it's definitely such a huge risk.
Yes. Could you say again what it is that you're asking of us?
So then, in this case formulation, to avoid that being the result for my client, to avoid the judge having to make that decision, how can I use DP, or if you guys see any way in which I can change the relationship that these parties have, because they once had a trusting relationship with one another. And when the court and lawyers got involved, now it's just attack on the personal characteristics. And I can't get my client, and I'm struggling right now to get the other attorney to stop doing the the personality descriptions and focus on the situation descriptions. And so that's what I'm asking for you guys to help.
You're looking for a strategy or?
Sure. Should I Google strategies?
Now, is this on the clock?
Unfortunately,
Unfortunately, it's off the clock.
we will have to use other times to answer the question.
I thought she did too.
So I wonder if everybody could thank Paula. and
Well,
Ms.
so-
Paula.
Thank you.
Regarding your original comment, in Kentucky, you're still brother and sister. In Tennessee, we haven't worked that out.
Oh,
Paula,
Yeah.
10 more minutes.
oh, apparently I do in fact have 10 more minutes if you guys are wanting to provide me feedback and comment. And you know what, David? I did ask my mom first, does anyone in here from Kentucky before I make that joke? Oh, Kathy, I'm sorry.
Hey, how's your brother?
Yeah.
Walter.
Does the mother recognize some competencies, some genuine interest on the part of the father?
So that's really where I struggle, Walter, is my own client in seeing any genuine interest, because he has made comments and has repeatedly failed to come to visits that are scheduled. We make arrangements for him to come from Montana and he doesn't show up. He fails to make his weekly Skype visits, which is where he can interact with the kids.
So why would that be a struggle with your client?
Well, because when he does do something, when he does do something that might be considered good parenting, she can't see it because she's focused on these other behaviors.
Well, when he does do something, does it qualify as enough in any way?
No, never enough. It's never enough. To her.
Would it be reasonable?
No, I'm saying enough, not to her, because I mean, she could easily disqualify.
Mhm.
I'm saying, from the perspective of
Of the court.
of an objective of a community standard, I should say,
Normative parenting.
in relationship to parenting. Is he an individual who tends to provide enough sometimes?
So, given what I know about the process in Colorado and what we allow for parents to do before we'll take a child away from them, yeah, it's probably enough to legal standards for parenting. But whether or not it's actually enough, I don't think that I'm in a position to really judge
But
that.
that's an important standard that you're saying, that one of the community standards is that we honor that status of biological parent.
Mhm.
And we give a lot of latitude to error
Mhm.
and inadequacy.
Yep. I don't know who was first. Isn't Ned supposed to be moderating this? Go ahead, Tony.
Bunch of ideas kicking around. I'm not sure which opinion you're going to be using. I'm wondering if, in fact, the way the legal system is structured here, the process is structured, if it's possible to. Thanks. Is it possible, maybe it's standard procedure, to have the issue of custody be focused on a specific arrangement that will do the least damage to the children's lives? So that, for example, all right, he can have 50-50 custody, but he's got to do it in such a way that it's not disruptive to the children's lives, which is say, he's going to have to travel here to do it. Is that in the picture?
It is in the picture, and that's what we've been requiring, and so that's where the attacks are coming from him, in that she's not taking into consideration what it costs him to travel here, and the time away from work, and so he wants a reduction in child support to be able to cover those costs.
To state the obvious, I mean, I
Yes.
take it that in fact, what happened here, dropping all the details, she got a judgment that says, you gotta pay this money,
Mhm.
and he's saying, shit.
Mm-hmm.
You didn't ask me, we didn't negotiate that, you got the law on your side, I'm a victim here. What have I got? Okay, I'm gonna go after custody. And why?
Mhm.
Because that gives me standing. Again, it recovers that. And
Yep.
I can't give that up because then I just am the patsy.
Well, and I think that's where his social legitimacy comes in,
Yeah.
is that, you're right, legally, he's got a right to these kids. And if he gets custody in any way, it reduces his child support. So, because they're equivalent with one another. And so you're right, absolutely.
And I guess one thought, I'm wondering if in fact one can do basically an accounting kind of maneuver here to get the guy to see that if he goes for custody and it all works out, it's going to cost him more than if he just gives the damn child support.
Oh, I do that. I always tell my clients, don't cut off your nose to spite your face. So don't engage in this litigation. Errol, sure.
Just to speak to that for one moment.
Yes.
Sometimes a helpful distinction to make with clients who are in the therapeutic context getting really caught up on making sure that they get some sort of like justice or like retribution for some wrong that had been done to them can be just to make the basic distinction between justice and results. Because often when we think about justice, we think about the other person somehow figuring out a better way to empathize with the victim or the perceived victim and to get some sort of apology or retribution, retroactive result. But often that can really undermine the results that they're looking for. And a lot of times this is also helpful with parents who are trying to make these kinds of negotiations more fruitful with their children, right? Which is like, well, yeah, you might be able to really spend all day going blue in the face trying to get this idea of justice to your kid who, walked right in front of your favorite sports program 10 times or something like that, if you feel like that's an offense. But at the same time, you may be better off by, getting them something else to be interested in at that time and giving them something to be stimulated by rather than worrying about making sure they know that they did something that bothered you or something like that.
Well, and that one works really well in business conflict also, and that usually when an employee is suing an employer, it's not for the money. I mean, sure, lost wages is easily calculatable, but when they say they want like $3.2 million, it's because they want an apology or recognition for the way in which they've been wrong.
Right.
So a really good one, yeah. Shirley?
Yeah, I'm not hearing anything about the children's point of view. Yeah, okay. I'm not hearing anything about the children's point of view. Being told your dad is going to Skype with you on Sunday and then he doesn't Skype. Being told he's going to come visit us in April and he doesn't show up. This seems to me extremely bad parenting.
Yeah.
And it really bothers me that hasn't been mentioned yet.
Well, it's been mentioned in the court case, and is certainly the highlight of my position when I go to court is you can't give these children to this father, Your Honor, because he's been absent. I mean, those are all absolutely the facts in which I can present a court case to help my client win. But what I want to do is get them to a place where she can encourage and support his parenting, and then he can rise to the occasion and be competent, or demonstrate that he will be. Because the children do, in fact, hopefully need a father, right? Need him. Carolyn?
Lane and I were just remembering the misery of custody evaluation and mediation. But really one of the most effective mediations I ever did was after the whole court process was well engaged, which it sounds like yours is, and the judge just said, go into another room with this woman, meaning me, and come out with a solution and tell your lawyers to get the hell out of there.
And you told me that one time at a study group, and what I think is so funny is that a judge can't actually take away your lawyer.
Yeah.
So that's an appealable issue, but it sounds like it resulted really well for that case.
The reason it worked well is the lawyers agreed. They
Yeah,
said,
they
we are
agree.
so angry and we are so unable to see the other person's legitimate,
Yes.
go back to your list of needs. We can't see that anymore. And that was why they agreed to it. Now, obviously, at the end, their attorneys had to be consulted and they had to agree to the solution. But
I
it takes me back to your, always paying attention to that list of needs. and making sure that as an attorney, you're getting it really clearly on both sides and conveying it well to your client.
Yeah, and the thing that I have in that case is I got an attorney who is so entrenched in it that I'm having to half the time make her understand her own client's needs, and that my offer is actually satisfying her own client's needs.
One more very quick question.
One more very quick question, Jane.
Do you have a sense of, if it weren't an equation that says the more custody I have, the less I have to pay, do you have a sense of what the father would ideally want in the way of time?
I do actually. Now I'm speculating, and in court that's not allowed, but in this room I think you'll give me some leeway. But if money wasn't an issue, I honestly think he would step out of the picture entirely. He's actually brought up the question of a paternity test because now he's challenging whether the kids are his. And so they're most definitely his, but I do think my client has run by the idea of could we offer to have him terminate his rights and I won't ask for any money. She's thought about that, and I think he might take it. But that's where we see an unknown constraint coming in, an unknown authority. What I didn't tell you was that his own father in Montana is paying for his lawsuit, and his own father has said those kids will get to Montana one way or another. So I don't think he's litigating this for him. I think it's being imposed upon him. And that's my time. Thank you so much.